Melissa McNeil on behalf of Mr. Cruz. Sherry Payne on behalf of State Attorney General. Lenny Banda on behalf of the State Attorney General.
Very well. Anyone else? Okay, let us proceed then with the petition.
Your Honor, thanks for having a hearing very quickly on this. We really appreciate it. You can see from our pleading, the department is asking this court to make a finding that good cause requires the release of this record to the public. Specifically, it is an Adult Protective Services investigation, one in which Mr. Cruz is involved. The statute 415-107-1, Your Honor, and I have a copy of it if you would like one.
I have it.
Okay. Well, Your Honor, the statute basically requires that good cause needs to be established for the release of the records, and Your Honor has to look at the records and basically weigh the good cause against the privacy interests that are within the records. I guess I'll go on forward with the argument, Your Honor, if you don't.
You may. Let the record reflect that the court did receive this morning from the Department of Children and Family a 3-page confidential investigative summary as well as 19 pages of other background and related information, which the court has reviewed in camera.
Thank you, Your Honor. Your Honor, the good cause for this release of these records, Your Honor, lies in the public interest in this case. There's no other way to say it. I think everyone around here, certainly everyone in this courtroom knows. What this stems from, a tragedy back on February 14th, last week Wednesday. It has pretty much saturated the news since then, Your Honor. It's certainly out there, and the amount of information that has come out is amazing, some of which that we may even consider confidential information that should not have ever been released already, but it has been. Several media organizations from Thursday of last week on have inquired to the department about any relationship the department had with Mr. Cruz or his family. Media organizations, both state, national, and international. It's clear that there is extreme public interest in this case. I don't know a better way to describe it than that, Your Honor. We believe that there is definitely, based on that public interest, good cause for releasing the information. Part of it is the fact that the bulk of the information contained in our report and those backup chronological notes, Your Honor, it was already in the public domain before we filed this petition. We filed the petition approximately 48 hours after the tragedy, yet within that time frame, most of the information in our record was out there. Furthermore, between the time we filed the petition and, well, within 6 hours, it seems, of when the petition was filed, it appears that someone may have leaked the documents in question. We don't know. We don't know. We aren't in a position to ask members of the press what their sources are. And I wouldn't expect the press to come running up and show us what they got so we can compare it to see if it's the real thing or not. But as it stands, there are many media organizations reporting on and claiming that they do, in fact, have these records. We are in no position to confirm whether they have the proper record or what they are reporting that comes from the records is, in fact, true. Any more that we would be in a position to confirm a lot of the private information that came out directly after the tragedy within the 2 days before the petition was filed and before the report was possibly leaked. So at this point, Your Honor, the department felt that the public interest in the release of this document was more than established at the time the petition filed, but since that time, based on the reporting and claims by media organizations that they already had both the report and the backup documentation, at this point, Your Honor, I see no reason to keep this record confidential. The information's not confidential any longer, for starters, Your Honor. And there are so many organizations, entities, that are reporting on stuff from this case. And the only involvement at all DCF has with this case in any way, shape, or form was one call, one report. and that's it. And what DCF finds themselves being in a position of being the party at the table, so to speak, who can't talk, who is gagged, because everybody else is talking. But one of the worst things is when people are talking and what they're talking about is wrong, incorrect, misleading, intentionally or otherwise. And that's even more reason for us to release this report, Your Honor. So when the public looks at the department, looks at the court system, and everything else surrounding this case, and sees where authorities, whether or not they did their duty and adequately followed the laws, adequately followed their own procedures, the public has a right to know that. In any case, I would argue, but certainly in a case of this magnitude. And so the whole purpose of opening up these records under this statute is so the public has confidence and knows that the department and the court system, when it is involved, the department and the court system have done the job and served the public the way they're supposed to. Now, the privacy interests are something that you also have to weigh under the statute, Your Honor. The privacy interests involved in these particular records. And I'd submit to Your Honor that the privacy interest in this record at this point is nearly none. The way these statutes, the reason these reports are made confidential to begin with, Your Honor, if you look at Statute 415-107, that makes these reports confidential and precedes the statute we are using to come to this court on. In order to protect the rights of the individual and other persons responsible for the welfare of a vulnerable adult. Those are the privacy interests that are involved here, Your Honor. Those are the privacy interests. In this case, there are two possible privacy interests involved in this report. That would be the alleged victim, and that would be the alleged perpetrator. One of those individuals, Your Honor, are dead. And I do not see how they could possibly have a privacy interest in this report. Now, it's unlike HIPAA, which HIPAA information survives someone's death and the confidentiality around it. There is no HIPAA-protected information or any other protected information in this report that should be protected on behalf of the deceased individual involved in this report. The only other individual that would have any possible privacy interest in this report would be the defendant, Mr. Cruz. But his privacy interest absolutely has to be weighed against not only the public interest, but in reality, the information that's already out there. And that information is practically, Your Honor, everything that the department has. 23, 24, give or take, pieces of paper. Much of it repetitive, redundant. There is not a lot there. But it is an official document of the Department of Children and Families, and it did touch this case. Mr. Cruz normally would have, like anyone, would have a privacy interest as a victim or as a perpetrator in this report. But Mr. Cruz has also been arrested and charged with numerous felonies, to say the least. And when you enter the judicial system as a criminal defendant, your privacy rights take a serious nosedive, Your Honor. And that is the case here. I mean, this information, the idea that this privacy interest in these records are greater at this point than the public interest, given that the information that's in these records is already out in the public domain, it really makes no sense anymore at this point, Your Honor, to keep this record confidential. The department does not want this record confidential because given that all the other information that's being released by various entities, however they're releasing it, the department does not want to release anything unless we have permission to do it, but we want it released, Your Honor, because we don't want to be the one party at the table that looks like they're hiding something or looks like they've got something to hide, because we absolutely do not. This was a run-of-the-mill case, Your Honor. I hate to say that, given everything that's happened since, but from the perspective of the people working this case, this was a call out, all the T's were crossed, all the I's were dotted, and we were in and out a very small amount of time, and that's it. But let's be frank, when the Department of Children and Families' name is involved with something, that quite often brings a little more attention, whether it's deserved or not. And the interest is very heavy on our records. Because it's true, we did have contact with Mr. Cruz. We did that. We admit that. We have to admit it because when the records were requested, we had to cite the statute that says why we can't give them that record. So it's clear that we have involvement, Your Honor. But at this point, the amount of information that's out there, including normally confidential information, and some misinformation that's also been bounced around out there, Your Honor. We are asking this court to find that we've established good cause to release this document and give it to the public so the public can have one more piece of this puzzle and try to figure out exactly where we go from here. Thank you, Your Honor.
Thank you. Before I hear from any of the media counsel, let me hear from the Office of Public Defender, Mr. Neal, Mr. Weeks.
Good afternoon, Your Honor. With respect to Nikolas Cruz and these records, we've also had an opportunity to review the petition and review the records that are subject to this petition. It's my understanding that there are 3 pages that include a summary and 19 pages that include case notes. That summary and case notes discuss Nikolas Cruz when he was a victim and a child and the subject of a DCF investigation.
Actually, let us correct that. He was not a child on the investigation. He was 18 and he was classified as a vulnerable adult.
You're correct, Your Honor. Classified as a vulnerable adult. However, after reviewing the records, we have only a limited objection, and our objection is to if the court is inclined to grant the petition and release those records, to only have an order entered with respect to those 3 pages as to the summary and 19 pages as to the case notes, and not be an expansive order that says that all of DCF records can be released, because that would include records that the court has not had an opportunity to review or could be maintained by providers for the Department of Children and Family Services. So with respect to those 3 pages and 19 pages, we do not have a objection, but we are asking the court to limit its order if it's inclined to release those documents to only those records that are the subject of this petition.
Before Mr. Jackson responds to that, I know there was a hearing this morning before Judge Scheer, who was assigned a criminal case, and your client was present. You waive your client's presence for purposes of this hearing?
Yes, we do, Your Honor. And any further hearings with respect to DCF records or this petition.
And if at a later time you decide you'd like him present, all you need to do is notify the court.
Thank you, Your Honor.
Okay. Mr. Jackson, any comment? Obviously, the petition, the supplemental petition before the court are limited to the 3 pages of the initial report and the 19 pages of backup. And Mr. Weeks' position on behalf of Mr. Cruz is that the limitation is only to those pages, which obviously the court has had the opportunity to view in camera. And that's required by statute and by case law.
Yes, Your Honor, we have no objection to an order like that because this statute that we're using to request Your Honor to release records would only apply to any adult protective investigations anyway. The statute will not open any record across DCF. Remember, DCF, child protection, food stamps, cash assistance, Medicaid, and the list goes on. But this statute is only for adult protective services, so of course that is the only records that we want released, possibly the only records we have. So, but it's only records that would come under this statute, absolutely, Your Honor. So we have no problem.
Mr. Weeks, with that understanding, I presume you have no objection on behalf of the client.
I have no objection, however, if the department does discover or learn of additional records that they believe fall within the purview of the statute, I would ask the court to instruct them to re-petition this court to release any further records that they may learn of.
The court is more than happy to enter a supplemental order that would reflect that. But I don't even think it's necessary, simply because clearly the department's followed the purview of statute and case law and has petitioned the court for an order of release and has furnished the court with documents for in-camera review. All right, who is here on behalf of the state that wants to speak on this thing?
Yeah, Sherry Tate on behalf of the state. We've been contacted by the Department of Children and Family Services and informed about some of the content, and by statute, the state attorney's office is entitled to get these records, and we normally would have taken a position that we would like them held confidential until the investigation is complete. However, we have been informed, as Department of Children and Family Services has informed the court, that these documents are already out in the public domain, and that there are no other documents that are not already out there. So based on the fact that they have already been released in some form or fashion, we are getting a copy of all the reports, and for that reason, we're going to defer to the court on your order today with the department.
All right, very well. And the court also wanted to just make a comment that these documents, which were prepared in 2016, obviously far predate any investigation from the incidents that occurred on Valentine's Day, 14. And as such would be difficult to be maintained as documents and purposes of an investigation for criminal prosecution. I think you would agree with that.
Yes.
Okay. All right. How about for the meeting? Yes.
We wouldn't have too much more to add, except to just join in the department's petition, and the department's arguments were very well articulated, and we simply would join those on behalf of the Sun Sentinel, Miami Herald, and CNN.
Just to add to that, Your Honor, I agree there's not much else to be said at this point from the media, just that Scripps, Univision, and ABC also joined the petition.
Okay. The court has had the opportunity, as the court said on the onset, to review the documents in question. The Department of Children and Families has filed a petition on Friday. Today they filed a supplemental petition. The essence of the supplemental petition was to allow release of the background 19 pages that accompany the investigative 3-page report. The department has sought a court order allowing the release of documents which would otherwise be confidential that pertain to the alleged abuse, neglect, or exploitation of a vulnerable adult. Prior to the commencement of this hearing, as the court has indicated, the court reviewed 3 pages of the confidential investigative summary and another 19 pages of other materials. The materials indicate that the initial intake to the Department of Children and Family occurred on September 28, 2016. The investigation was closed on November 12th of 2016. DCF seeks to release these documents to allow the public to determine if the department adequately performed its duties of providing vulnerable adults with proper services. Additionally, there are issues that pertain to the public's right to know, which have to be balanced against the privacy interests of those involved. The reports themselves classify Nikolas Cruz as a vulnerable adult due to mental illness, specifically due to depression, ADHD, which, by the way, the media has referred to, and I believe Mr. Cruz's counsel, as ADD. But these reports reference ADHD, which would be attention deficit with hyperactivity disorder, autism, and that he was taking medication as a result of these issues. At the hearing this afternoon, Mr. Weeks, on behalf of Mr. Cruz, has waived his appearance for this hearing and ostensibly for other related hearings. The legislature has provided a mechanism in Section 415-107-1 for the court to review documents and to release documents or materials which would otherwise be confidential information. This case has been publicized, as has been commented by Mr. Jackson from DCF, not just throughout the state or throughout the nation, but throughout the world. Nikolas Cruz on February 14th, on Valentine's Day, went to the Marjorie Stoneman Douglas High School in Parkland, Florida, armed with an assault rifle and with ammunition. Over the next several minutes, he murdered 17 students and faculty members and wounded over a dozen more. Upon his apprehension, according to the arrest reports, which are part of the court's files, he confessed to the shooting. Numerous media organizations, as attached to the initial order, or petition, I should say, for disclosure and release of these documents, requested information from DCF for records relating to Nikolas Cruz. This court serves a crucial role in analyzing the rights of privacy and confidentiality against the public interest in disclosure of accurate information. Courts have to determine if good cause exists for public access to records that the department and the media seek to release. So much has already been presented through the media, much of it is attached to the initial petition, and the court has, of its own, observed through the media, whether it be newspaper, television, recounts of information that is clearly contained within these reports. The public has a right to know whether the information that has been broadcast and disseminated is accurate in order to evaluate the performance of the Department of Children and Family in discharging their obligations to vulnerable adults in this community. If there are shortcomings in the department, the public has a right to learn the shortcomings as a prerequisite of correcting those shortcomings. Neither the Office of Public Defender representing Mr. Cruz nor the State Attorney's Office object to the release of these documents. The documents reflect an investigation which classified Nikolas Cruz as the alleged victim of neglect or inadequate supervision. It named his adopted mother, Linda Cruz, as the alleged perpetrator. The report, which was concluded on November 12th of 2016, found that his mother did not mistreat him, that he was receiving adequate care at Henderson Mental Health Clinic, and that he was attending school. His mother passed away last November. Her privacy rights are primarily extinguished as a result. Mr. Cruz's circumstances changed after his mother's or adopted mother's death, but that is not reflected within this report or investigation, which concluded approximately 16 months prior. The public has received information about Nikolas Cruz's life, about his adoption, the death of his adoptive father years ago, the death of his adoptive mother recently, the struggles that he had with depression, with ADHD, with increasingly difficult to control behavior, with educational concerns. The public has learned of interventions by DCF, by educational counselors, by mental health counselors. The court recognizes this balancing test and the right of privacy to both the alleged victim and the alleged perpetrator. Nikolas Cruz, by his actions, by the fact that he has been charged in a criminal proceeding, by the statements which are reported within his booking sheet and probable cause affidavit, waive those rights. And the court independently finds that in addition to the fact that his counsel has no objection to the release of these records. In conducting the balancing test, the court has to balance the public's need and right to know how and whether this tragedy could have been prevented. The public has a need to be provided with accurate information. The public should have the opportunity to properly evaluate the actions of the Department of Children and Families and all agencies that interacted with Nikolas Cruz prior to February 14th this year. Therefore, as a result, good cause exists for the release of the department's records, which were part of the petition and supplemental petition today, limited to the 3-page confidential investigative summary and the additional 19 pages of background materials. Now, DCF has sought redaction of the names of non-DCF employees, and the court grants that request. However, DCF has also, in its materials provided for in-camera review, has also suggested that the court excise or redact the titles of these individuals. The court declines to do so. The court finds that the titles of the individuals involved are relevant, are material, and make the report complete so that the public and all involved have a full ability to understand the investigation and what occurred. Is there anything further that anyone would like to add? Hearing nothing, then the court will enter its written order of findings. And upon doing so, the court needs, or let me ask Mr. Jackson, Ms. Costa, how do you intend to release these documents as far as the redaction of those individual names?
Well, Your Honor, we have various ways. We're pretty open. What we're hoping is that, for starters, interested parties that are attending this hearing will approach our communications specialist after the hearing and provide a contact information, etc., so we can get these reports to them ASAP.
Clearly, the department has not sought the redaction of its employees' names, and the court does not order that redaction. It is simply to other individuals, whether they be school individuals, mental counselors, mental health providers, that their title be disclosed, however, the name for the time being will remain redacted, subject to further motion if necessary. And at that point, obviously, those individuals interested would have a right to be heard. Okay. There's nothing further. The court will enter its written order. The court will have copies available for anyone who so desires. And with that, we'll stand in recess.
Thank you.
Thank you, Your Honor.
We're off the record. 1 second question. The clerk's office, or we can stay back on the record. The clerk's office has been trying to put together a file. In mental health, the filings are not just e-files, they're hard copies. And so I have the reports, etc., but I have a complete unredacted report that I presume has been furnished to the clerk as well. So that file remains confidential, and the only thing that will be disseminated will be the documents through the Department of Family, Children and Families. Is that acceptable to everyone? Does that work for the media as well?
If I understand, Your Honor,
Yeah.
it's saying that the court files themselves will remain confidential.
By statute, mental health files are confidential.
We would ask that the petition be,
Well, the petition itself is already out there as well, Your
and the
Honor.
supplemental petition,
As well as the supplemental.
and the order.
Do you, well, of course, the order one, you'll have a copy. Do you, can you provide all interested parties with a copy of your petition, supplemental petition, the attachments?
Yes, Your Honor, we can take care of that. And I'm not 100% certain, Your Honor, it's my understanding that we did not file the investigative summary with the actual petition that was filed with the court. But I will go back and double check my files.
Let me see, because I have what was hand delivered to me, but it had a cover sheet on it that said e-file documents included delivery to the judge. That's where the court's coming from.
The FSFN, Your Honor, was not filed.
Okay, apparently the clerk does not even have today's supplemental.
It was filed earlier today, Your Honor, I received
So
confirmation.
the clerk will need a reference number to that.
Okay.
This will be a reference. I'll just give you a copy of those.
Yes.
And there are some copies, where you can get them. There's those, DCF, media, Trump Defender, and, no, and, state attorneys. We'll start there and see how you get along.
Ron, may I approach your clerk?
Sure.
Thank you, sir.